let's first turn to the law. Abhimanyu Bhandari is advocate at the Supreme Court, has written an excellent book on the PMLA. Also joining me is Bishwajit Bhattacharya, former ASG, is joining me. Appreciate both of you joining us. Abhimanyu, to you first as an expert on PMLA. Is it significant that here is the Supreme Court granting bail to Sanjay Singh and also saying significantly that they haven't found a money trail in this case, and the ED doesn't oppose the bail? How do you read it?
No, I think the development today is welcomed. It's welcomed on various counts. One, the ED itself comes to court and says, the lawyer for the ED comes and makes a fair statement that, look, we are ready to make a concession here. Please grant this person bail. So therefore, the court has not had an opportunity to hear the merits of the case and make any finding on the merits of the case. One. Second, the court also clarifies that this cannot be treated as a precedent, because do remember that in this case, there are a large number of very famous personalities who are in judicial custody as on today. So therefore, what happens today cannot be treated as a precedent by other persons, whether they are private individuals or public personalities who are in prison at the moment trying to get a bail. So therefore, while it is welcome that the ED has made a concession, I think it is not it's not a very clear precedent which can be used by other accused to argue, because Sanjay Singh has got bail, they should also be entitled bail. But Rajdeep, the larger question here is, and the more important question here is the law on bail when it comes to an ED offense. Why is bail, as you started the show, why is it becoming such a big thing or so difficult to get a bail? Please remember that the ED Act, the PMLA Act, which came into force, had a very rigorous condition for bail. It said that anybody who's been taken into judicial custody or has been arrested by the ED has to convince a court of law that that person has actually not committed the offense to try and get the bail. Now, this what is called a twin condition restriction is so draconian that how can someone who wants to get bail try to convince the court that, look, I have done nothing at such an early stage of the proceedings, so that the court is convinced to grant that person bail. So people languish for months in jail, because it is very difficult for any accused to come out of there and say that, look, please be convinced that I have not committed the offense. If that accused can convince the court that I have actually not committed the offense, then he can actually get acquitted. So
and presumably, Abhimanyu, these amendments were brought in 2018 through a money bill. So they went through the Rajya Sabha and the Supreme Court ratified it in 2022. But you're saying the basic premise of Section 45 of the PMLA is against our jurisprudence, which says bail, not jail. This has completely reversed the proof. Am I correct?
Yes, correct. But Rajdeep, what is more important is Supreme Court struck down this Section 45. Supreme Court came heavily down in a judgment called Nikesh Tara Chand of Justice Honorable Justice Nariman and Justice Kaul, saying that this condition that you have to satisfy the court that you've committed no offense, this condition is not correct, and it is not in sync with our constitutional and fundamental right to liberty, and therefore struck it down. But what happened after that was that a larger bench of Supreme Court, 3 judges of Supreme Court in Vijay Madan Lal Chaudhary, said that the act was again amended and a new provision brought in, and therefore that judgment was held not to be good law anymore. And in that way, those twin conditions again got revived back.
Right. And
matter is now pending before a review bench, because notice has been issued in open court and review will be heard, I think, sometime in July. So therefore, Rajdeep, the big picture is that Supreme Court had once upon a time actually struck down this condition. And if that judgment continued, people would get bail quite easily, just like they get bail in Prevention of Corruption Act offenses, or they get bail in cheating offenses or any other economic offenses. There is no need to have these twin conditions in the PMLA, because do remember that PMLA is a 7-year offense, which is just like any other offense in the IPC, whether it is cheating, whether it is some of those Prevention of Corruption Act offenses. So therefore, to have such a draconian condition where a person is told that you have to convince the court that you've committed no offense cannot, in today's time, according to me, be stand in a statute book.
I take your point and very strong words from you, Abhimanyu. But then what explains, Bishwajit Bhattacharya, the kind of U-turn the ED suddenly makes in court today, saying we are not opposing it? Is it because the ED feared that if they opposed it, it would go on the merits of the case, wherein the merits of the case would suggest, as per the Supreme Court, that you haven't found a money trail linking it to Sanjay Singh yet.
ED knows very well, as Justice Khanna of the Supreme Court observed, that no statute can override constitutional rights. Section 45 is a statute. It says, notwithstanding whatever has been contained in Code of Civil Procedure Code, it cannot and does not say notwithstanding the Constitution of India. So I find this entire debate of Section 45 being draconian and the constitutional courts are fettered in their hands and they cannot grant bail, I mean, if I may use a very strong word, which I should not, is utter nonsense. Rajdeep, with the greatest of respect, I submit before your distinguished viewers that even before Section 45 of the PML Act, which talks about the reverse, presumption of guilt, in the repealed Foreign Exchange Regulation Act of 1973, there were two sections, Section 59 and Section 71. There was reverse presumption. So this is nothing new. So I am very, very utterly surprised and shocked. The entire nation has been debating about Section 45. It is not a big deal.
No, so are you saying that the Supreme Court or indeed any court still has a lot of leeway to grant personal liberty to a citizen who's accused under PMLA? Because look at the track record, barring a few cases. That's why Sanjay Singh is an exception. The fact is, as Abhimanyu pointed out, generally people are spending 6 months a year, even more. Look at even the case of Manish Sisodia. Look at how much time he spent in jail.
It's wrong. It's wrong. I say 100 times Manish Sisodia being incarcerated without a shred and iota of evidence for more than a year is utterly wrong. Rajdeep, I want to make it very clear to your audience. Kindly, I have already stated, I am reiterating, constitutional courts cannot be bound by statutes. That the fundamental law, which the law students first and the entire lawyers fraternity and judiciary must appreciate, Section 45 cannot stand in the way of granting bail.
Okay, you made that point and you're making it emphatically.
One more thing, Rajdeep, yes. May I just say?
Yes.
And, fundamental right and human right under Part 3 of the Constitution and also Article 20, Subclause 3 of the Constitution, you arrest a person and you say he is not cooperating because you are expecting him to answer so that without any investigation, he straightaway records your statement. I am sorry. No accused can be expected to toe the lines of any prosecution to prove the case of the prosecution. So I find, with the greatest of respect, and may I also say on 22nd of September, 1998, I had contributed as a witness in the Parliamentary Standing Committee of Finance chaired by the late Murli Devra, when 50 members of parliaments were there, all the political parties were there. We were 3 witnesses. I was fielded by Confederation of Indian Industry. I spoke throughout the day. I kept on answering. Myself, late J.B. Dadachandji and Mr. Ashwani Kumar. So the intention of Parliament was bifurcated Foreign Exchange Regulation Act into two. One to Foreign Exchange Management Act, which is not criminal, and Prevention of Money Laundering Act. Now you are going on expanding the schedule offenses, like even the prostitution, like the Prevention of Immoral Traffic Act can also be deemed to be money laundering. What a ridiculous state of affairs is this.
I take your point, Vishwajit Bhattacharya. I just want to bring in, though, Abhimanyu, for one final word, Abhimanyu, on what happened today mean for Arvind Kejriwal? Because as you said, the court made it very clear, this is not a precedent, these are peculiar circumstances. But the fact is, in some way, this is also seen as a conspiracy case. And therefore, if one person gets bail, does it make it easier for the others? Or are they all to be treated as separate cases, given the fact that the ED now claims that Mr. Kejriwal is the mastermind?
Rajdeep, according to me, what has happened today will not come to the rescue of any other accused, whether it is Mr. Kejriwal or Mr. Sisodia. They would have to stand on their own feet and they would have to argue and show to the court that there is a case here they've made out which shows that there is no reasonable prospect of any conviction and that they satisfy the twin conditions. I don't think so. The fact that Sanjay Singh has got the bail will in any way help Arvind Kejriwal's legal argument or Manish Sisodia's legal argument. They'll have to go to court and convince why they should be granted bail, and they will have to satisfy the rigors of Section 45 and the twin conditions that are contained there. Yes, of course, politically, and, the perception now would be that, look, because ED has conceded on Sanjay Singh, maybe the environment is that others would also try and make out a case that if one person is out, we should also be out. But Rajdeep, having been practicing as a PMLA lawyer for many years now, and knowing this, I don't think so that this can be treated as a precedent. Rather, if I'm not mistaken, the order very clearly says that this case cannot be treated as a precedent by other accused in this same right. ECIR.
And in fact, we've got a flash which says that the Supreme Court has now removed the statement from the order where it said Sanjay Singh can participate in political activities. So we will wait to see how those conditions of bail also operate. But for now, Bishwajit Bhattacharya and Abhimanyu Bhandari for giving us a sense of PMLA, its implications and how bail works in PMLA. Thank you so much for joining me here at the top of the news today.